And the crucifixion of Zeus, the Jew. Ironically, their leader, the whale, well, look him up. I will leave it at that. It's funny how history repeats itself. Yet, man convinces himself his actions are justified. It did not matter that the Hodunks worshipped Jesus, who was Jewish. They would still find a way to justify attacking a man they don't know simply for being Jewish.
Crucify Zeus! Crucify the King of Jews. Loyal supporters, we will not allow a Jew to get in our way.
And every Sunday, the Hodunks, never seeing the hypocrisy in their own behavior, faithfully would attend church, claiming to be born again and that they are the chosen people of Christ, a Jew. And 6 days a week, they act no different than Pontius Pilate and the Romans acted toward Jesus. Confused? Yes. Trust me. I am too. But to simple-minded people like this, with no education, they can justify the most idiot rationalizations in their primitive minds. And so began the crucifixion of Zeus, the Jew. Ironically, their leader, the whale, well, look him up. I will leave it at that.
All right. Hello, everybody. I am here today. I thought I'd go live for a little bit because there's a whole bunch going on with Jeremy the Germ Hales and Randy Pocket Rocket Shocket and their whole little crew over in Otter Creek in Points Unknown and in cyberspace, I guess, in the YouTube world. But there's a bunch going on, and I put out an article earlier today talking a little bit about what we saw in the intro, and that was an old video that we're bringing back. We're resurrecting for all things. We got the crucifixion of Zeus, and that's of course Bruce Madskin. That was a very bad name, a bad name that that Jeremy Hales uses for an attorney, and he's a very good attorney from Massachusetts named Bruce Madskin. And he's had a whole bunch of cases that are, media attention type cases that, he's been, fighting with people, really bad people on his cases. So, we talked a bit about the macaroni and cheese case with Kerry Dooley, who's the judge up in New Haven. He was on that case. And he did some other stuff, but he got involved in this Jeremy Hales case. And he's kind of was like collateral damage to start with. And then, Jeremy and Randy, Randy the Pocket Rocket decided to make him like a boogeyman. He's like the main boogeyman now. If anything happens, there's like two people that they blame for everything. They blame Bruce Madskin and they blame Lisa Lee. If anything happens, if Jeremy Hales cuts himself shaving, if they break a dish, it must have been Bruce's fault or it must have been Lisa's fault, and that's how these people operate. They operate by demonization. They really don't have anything other than that, and it's the story, older than time. But we're going to go through some stuff today. We're going to go through actually the article I wrote. I'll put it up on the screen so everybody can see. But this is the article that I wrote today, and it is about the Florida courtroom content farm. That's the name of the article, and really the core of the story is what Jeremy and Randy Shockett did to basically weaponize a bogus claim of unauthorized practice of law. That's UPL. You're going to see UPL all over the place. That's unauthorized practice of law. And so this story actually talks about it. It talks about what they did, and it's not in the Fed 2 case. It's not in the Fed 1 case. It's actually in the Levy County case. And that Levy County case has Jeremy Hales as a defendant, also has Martha, also known as George, his Middle Eastern concubine. And it has another guy named Larry Foreman, who's a lawyer, It's got another person as well, but those are the three, important ones for the purposes of this story. So this is Bruce Matskin right here. Okay, Bruce is a lawyer. He's a pretty good lawyer up in Massachusetts, and he came in and he was representing Michelle Preston, John Cook, for a while, pro bono in the federal cases. And the whole crux of the story is about how there was another lawyer on the case, and that lawyer, he died actually. That's the sick part about this whole thing, is that he died, and Jeremy made fun of him. And I'll show you a picture of the lawyer here. We'll get back to that. This is Scott Stark, and he was a lawyer for Michelle Preston and for John Cook, and actually, he was actually on the phone with Bruce a little bit, talking about different things in the cases. And this is what lawyers do a heck of a lot, is that they talk with other lawyers. And I think that's the way that it works in any profession. As a journalist, I talk to other journalists. I talk to Mike Volpe all the time. I talk to other people from all around the country about different issues, about, journalism, about if something happened, if I have a problem with a source, if I have some questionable evidence that I'm looking at, or documents, and how I go about getting more documents, FOIL requests. You talk to other people who are in your business. It doesn't matter what you are. If you're a plumber, you talk to other plumbers. If you're a baseball player, you're going to talk to other baseball players. If you're a pilot, you'll talk to other pilots. So that's just how it is. And so Bruce was talking to Scott Stark, and basically it was a situation where Bruce had represented, I don't know if he previously had represented, and this is the time when he did represent Preston and Cook. And it's always smart with people who they have common lawyers. They have several different lawyers for several different things, and they'll talk about things. But these guys, Hales and Shockett, took it to a new level. They tried to claim what's called the unauthorized practice of law. They're saying that Bruce Matskin actually engaged in what's called the unauthorized practice of law in the state of Florida. And that, if anybody knows about that, that's a very serious charge. That's actually a felony in the state of Florida. And so I'm going to start from the middle, and I'm going to put up the actual order that they had put in that says that Bruce had was unauthorized practice law. I think this is it right here. Here it is. So this is in last December, and they go in, and it was a bit of an ambush type motion, and we'll get into some of that in a second. But the ambush motion comes in, and then there's an order by this judge, and this judge's name is Grobe. He's up in Levy County, and we all know Levy County because that's where there was a guy named Dan Owen, who's the state attorney. He works for James Uthmeyer, who's the Florida Attorney General, part of the executive branch in Florida, and he's a good public servant. And Jeremy Hale sued him. He sued him in federal court, and Florida won. Obviously, the state of Florida. You're not going to beat the state of Florida, especially if you're not Jeremy Hales. And so that was that's Levy County. But this is actually not a case in federal court. This is a case in state court. And state court in Levy County, Florida, it's what's called the 8th Judicial Circuit. And you have the judge here, and I'll show you his name. I'll show you a picture of him in a second. But this is him, Robert K. Grobe. That's the circuit judge. And so this is the core, thing. Cut away the fat. This order right here is the center of really what we're talking about. And it's a string that you can pull to get to these Florida federal court content farm, the Florida state court content farm, what Bruce Matskin likes to call Palamop. If you understand what's going on to create this document, this order, that what precipitated the creation of this order, you understand how Jeremy Hales operates. You understand his modus operandi. You understand his common scheme or plan, and how he conspires with others and those who act in concert with him, and those are sometimes can be called his co-conspirators. So what this order did was it made all these findings, and I'll read it first, and then we'll go through it, and it's kind of like out of control, and I'll explain why as we go. So it's an order granting motion to strike unauthorized communications and for sanctions for unauthorized practice of law. Sounds pretty terrible, right? This cause came before the court on December 17, 2025, upon defendant Jeremy Hale's motion to strike unauthorized communications for sanctions for unauthorized practice of law, Doc 95, and the court hearing argument of counsel and being fully advised of the premises, it is hereby ordered and adjudged as follows. Excuse me. Defendant's motion is granted. That means Jeremy Hale's, Martha, the Middle Easterner, Larry Foreman, the DUI lawyer, and this other Taron Graves, their motion is granted. The court finds that Bruce Matskin is not licensed to practice law in Florida and has not been admitted pro hoc vice in this matter. Okay, that's pretty clear. He's a Massachusetts lawyer. The court further finds that Bruce Matskin has engaged in communications with the court and parties in this case, including emails dated October 6, 2025, October 7, 2025, October 9, 2025, which constitute the unauthorized practice of law, a third-degree felony per Florida statute 454-23, referable for prosecution to the Florida Supreme Court. Okay. 4. All communications, including emails and any legal documents sent or prepared by Bruce Matskin in this case, are hereby stricken from the record. Bruce Matskin is hereby admonished for engaging in the authorized practice of law in Florida without proper admission to the Florida bar or pro hoc vice admission in this case. Bruce Matskin is hereby enjoined from further communications with the court until properly admitted pro hoc vice pursuant to Rule 1200, the Florida Rules of General Practice and Judicial Administration are associated with the Florida Counsel who actively participates in the matter. Plaintiff Michelle Preston is hereby ordered to identify to the court all parties that name anyone not licensed to practice law in Florida who has not been admitted to pro vice in the court who gives legal advice to her in matters before this court, drafts paperwork on her behalf, which is then submitted to the court in the future. The court reserves jurisdiction to enforce the terms of this order. And that's Robert Grobe. That's this guy. So this is this order. It sounds terrible. And I guess if we remember a few months ago, this was a big to-do, around Christmas time. Oh, Bruce! I remember Bruce is going to jail! Bruce is going to go to jail! He's going to jail! And so it's like, I'm going to tell you right now, I don't want to be anticlimactic, but it's a big nothing burger. And we'll go through why it's a nothing burger and why this actual order is probably going to be overturned. But the biggest reason is this. I'll put it back up there. Here's what we have to show. We have to show that this order is, look who the parties in the case are. Michelle Preston is the plaintiff. Jeremy Hale's Martha Risk, Larry Foreman, Taron Graves are the defendants, right? Do you see Bruce Matskin's name anywhere in that caption? I don't know. If anybody's watching, if they see it, let me know if they see his name there, because I don't see his name. And one of the basic rules of jurisdiction is that you have to have jurisdiction over the person in order to be able to say anything about them, to have a ruling, to do this, to do that, to do the other thing. And so this is an order without jurisdiction. Yeah, everyone's going to jail, right? Everyone's going to jail. That's according to Germ, everyone is going to jail, right? So the issue is there's no jurisdiction over Bruce Matskin, and this judge kind of shoots himself in the foot here on the face of the order. If you look at this, the second thing it says, they find that Bruce Matskin is not licensed to practice law in Florida and has not been admitted pro hoc vice in this matter. So he's not a party to the case, nor is he a member of the bar. So what is the jurisdictional hook for having Bruce Matskin, who's sitting up in his house in Massachusetts, present and appear before this court? Right? When you think about it, there's nothing that Bruce has done that avails him of this court. Right? He's not a party, and he's not an attorney admitted in Florida. So a Florida judge cannot say, okay, you are, I'm going to make an order about you. It just can't happen that way. So that's a big problem that they have here, that he's there as a party without being a party. He's being named in here and telling you got this and that, and you're admonished and you're in trouble, but he's not even, there. There's no there. So that's one issue. The bigger thing is, and we'll talk about this. We'll talk about how the content farm happened, right? So they did this, and really the word that they wanted to get in there was that word felony. Everybody's going to jail. Everybody's going to jail. So once they got that word felony in there, they got to say, look, it's a felony, third-degree felony per Florida statute 454-23. And so but what does it mean? You're saying that there's a felony under the law for somebody I have no jurisdiction over. And we'll go to my article, and the article itself actually says it pretty good. It says it pretty well. It talks about what's going on in this case. And there's Bruce, and here's the order we just went through. And so, the end of the fact is that this is, it's totally, first and foremost, contradicted. And so Scott Stark, who we just talked about, who was the lawyer who died, had a deposition, and he talked about what was going on in the case, and he said that this was my complaint. Of course, I talked to Bruce Madskin. Of course, I did a whole bunch of stuff, but at the end of the day, I signed the complaint. It was mine. This, that, and the other thing. And the other part of this is there's a smoking gun that we don't hear about. And that smoking gun is in the form of, and let me get down to it. It is an email. Let's see if this is it. That's the smoking gun right here. If anybody can see, if you can see this is the best part about this. That order came down on December 18th or something, right before Christmas. The judge was being the Grinch who stole Christmas. And so this came out November 14th, 2025, and it's from Michelle Preston, aka Lynette, some person that a lot of people know. And it's addressed to Miss Thomas, and Miss Thomas is the court attorney for Judge Grobe in Levy County. And this is basically addressed to the court. This is the party, Michelle Preston, telling the judge what's going on. Miss Thomas, Bruce Madskin has not pretended to be my lawyer or acted as my lawyer. Bruce has continued to advise us and have maybe ghostwritten a motion at some point to help us, but he has not represented us in any way since we released him. This is, again, another contrived lie from Mr. Shockett and his client, Jeremy Hales, just to cause more problems and get more content on YouTube. And it has already been broadcasted on YouTube. Man, this is an injustice to the legal system. And to me, it's harassment, and it's abuse, and it's continuing. And the courts are allowing it. You are allowing these people to abuse me, use me, hurt me, to find me liable, then take away my life, is killing me physically, to continue to lie, to manipulate the judicial system. I'm asking for you to please put a stop to Mr. Shockett and Mr. Hale's lies and wrongful attempts to sue this court to their side. I'm not a lawyer, of course, and I don't know how to do these things properly, but I will be petitioning again for a court-appointed attorney because this is no longer a little tiny case of so value. This is a manipulated scheme on the part of Jeremy Hales to destroy me and my child and Mr. Cook for content on YouTube. And I ask the court to please stop it before yet another person dies or physically injured for life because of what they continue to do as harassment and cyberbullying and now bullying through the court system. Sincerely, Michelle Preston. Now, she sends this in there, and, I would think that that's pretty damn good evidence right there from the party in the case. If there was any question in Levy County, Judge Grobe could have called Michelle and told her, okay, he'll swear to this or whatnot, but that's pretty good evidence. Yet this judge acted anyway, and this judge decided, I'm just gonna go in there and I'm gonna do what I want to do, and I'm not gonna really care what the person says there. So that, I think, was the smoking gun, and the statute itself, and I'll get to it down here when we talk about it in the discussion. it really was never meant to be what a lot of people say it is. In this case, it was never meant to be for people helping other people that, informally. It's means for somebody walking into a courtroom and pretending they're a lawyer. Like, throw on a suit and tie and go down to the local court and say, yeah, I'm John Johnson. I'm a lawyer. I'm going to represent these people and blah, blah, blah. That's what the statute is made for. That's the felony portion of what's there. So we talk a little bit about it. And here's the guy that I talked about before. That's Dan Owen. And that's the Levy County Courthouse. And what they're doing is they turn this into a content factory. And, that's the issue. And here's the guy, Randy Shockley. He looks as charming as a serial killer here in this picture. The problem we got with Randy Shockett is that he's co-signing on everything that Jeremy Hales is doing. And the fact of the matter is, I think it's kind of worse what he's doing. I think Jeremy's bad, but I think like Shockett is worse because he should know better than to do what he's doing to everybody and allowing Jeremy to do what he does. And we just heard from Michelle's email back in November, and her story hasn't changed. Back in November, how this is harassment is killing her. It's killing her kid. It's killing her family. It's terrible, terrible stuff. Now, this is the what happened, and you can read the story, but this is the notice that Shockett had put. Remember, you see that order was December 15th or December 17th. This is December 5th, a week before, and he did a notice in motion of hearing set by Judge Grobe. There was no notice on here that there was going to be an unauthorized practice of law. There was going to be a felony. There was going to be anything else. Moreover than that, they served Bruce Matskin by email, but he's not a party to the case. He hasn't been served personally. And so this is like, not a good way to get somebody into the court. You need to actually have jurisdiction to bring people in. So here's the judge. Okay. Judge Grobe. Okay. Now, Judge Grobe basically sat there, and what our understanding is that Shockett drafted the order that we just read. So Shockett was the one who wrote the piece of paper and handed it to this guy, Judge Grobe, and Judge Grobe signed it. And it's like totally no jurisdiction. It's totally illegal relief. It's a lot of that stuff. And my understanding is that Bruce has a lawyer that's going to go in there and open it up pretty soon. But, we'll see what happens there. When that happens, it happens. But the fact that this guy right here talked about Bruce Matskin and talked about his sanctioning as a lawyer, it was actually legally wrong. Then I'll read everybody the rule. Okay, Florida, Article 5, Section 15 of the Florida Constitution gives the Florida Supreme Court exclusive jurisdiction over admission and discipline of attorneys. Florida unauthorized practice of law cases are traditionally brought by the Florida bar in the Florida Supreme Court, not built through a private litigant's motion in a circuit court side fight. The Florida Supreme Court unauthorized practice of law cases such as the Florida Bar versus Brahma and the Florida Bar versus Shramik confirm that the bar brings these matters to the Supreme Court when seeking unauthorized practice of law injunctions. So there was an injunction here on Bruce Matskin, and this judge had no business doing the injunction. Under the Constitution of the state of Florida, the Supreme Court has to do it, and the Florida bar has to be the petitioner. So Hales and Shockett argue that Matskin crossed the line by sending us substantive emails and preparing documents without Florida admission. That's their theory, and it runs straight into the First Amendment. And we're going to talk something here about a couple of concepts that a lot of people know a lot about. One of them is called due process, right? Due process of law. And the other one is part of that's notice and an opportunity to be heard. But another thing is called the right to petition the courts for redress, or the petition the government for redress. And I'm going to talk about that right now. The Constitution protects the right to petition the government for redress of grievances. That's the United States Constitution Amendment 1. That's actually in the First Amendment. Next time you have a chance to look at the Constitution, you'll see that there's the right to free speech, a right to a free press, right? There's the Establishment Clause, no establishment of a state religion. And then there's also the right to petition the courts for grievances, for the redress of grievances. That includes access to the courts. The Supreme Court has made it clear that the right of access to the courts is one aspect of the right of petition. Right? That matters, right? Why does that matter? Because the conduct labeled as unauthorized practice of law emails to a clerk, helping with filings, falls squarely within petitioning activity. Unless it is a sham, it is protected. And you know who said that? The Supreme Court of the United States in both the California Motor Transport Co. and the B&EK construction case. In both those cases, okay, they said, and in other cases, this is what's part of petitioning and your heavy right to petition. You're not engaging in the practice of law. Bruce didn't get up and put on a suit and go down to Levy County Court and say that he represented anybody. Bruce didn't even file any documents. All the documents, Michelle Preston said she filed herself. She prepared. She had a little bit of help. But at the end of the day, when you sign the documents, Bruce didn't sign the documents. Michelle Preston did. So Hales and Shaka's position boils down to this. Only they get access to the courts. That's what they want. You can't say that. You can't do that. You can't say that. Only we can. That's what they want. Rules for thee, but not for me. That sums it down in a nutshell for Jeremy Hales. Rules for thee, but not for me. So Hales and Shaka's position boils down to this. Only they get access to the courts, but the Constitution says otherwise. A close read of this records points to something harsher, a harsher possibility. This was not about protecting the court or policing the bar. It's not protecting the sanctity of the court. It's not protecting people with law licenses. This was about Palamop, manufacturing a headline. The objective here by Jeremy Hales was to have an order stamped with the word felony, not because it was legally necessary, but because it was useful and beneficial in content creation. Once that label existed, it could be recycled everywhere. Bar complaints, settlement leverage, and critically, content creation on YouTube. In that light, the courtroom looks less like a forum for the adjudication of grievances and more like a production stage. And that's what Jeremy Hales is doing. He's turning the courts in the state of Florida, the state and federal courts, into a production stage. The unauthorized practice of law label became the hook. The order became the script, and the fallout becomes the product. So his content, he's slinging his content. That's what he does. And we know that that's not how judicial content's supposed to work. And so we sent some emails. We sent one to Candace Thomas, who is the court clerk for Judge Grobe, and she didn't answer us back. Right? But here's the other guy. There he is. Who's this guy? That guy is Larry Foreman. Right? Larry Foreman. And so Larry Foreman is a lawyer. He's a lawyer from Kentucky. And so he's a defendant in this case. We know that he's a defendant in this case. And what does Larry Foreman do? Well, he does what most lawyers do that are scumbags. He acts like a scumbag lawyer. So the scumbag lawyer, what did he do? They got that thing that said felony on it. And the second they did that, they did scumbag things. Watch. This is a settlement communication, right? That was sent. Do you see the date? December 31st, 2025. This was sent to the lawyer for Bruce. And this is in the other case, this is saying, Ben, the purpose of Ben Potash, Ben, the purpose of this communication is to make a settlement proposal on behalf of my clients in this case. And that Rogers is the lawyer, and his client is, good old Foreman, Larry Foreman. We believe our clients have a substantial likelihood of success on the merits of the interlocutory appeal under UPEPA, where the matter is subject to an over-review. However, before incurring further expense in pursuing the appeal, our clients have directed us to make the following offer. Mr. Madskin would pay our clients legal fees and expenses up to date in this case. That's number one. Number two, the parties would execute standard releases and dismiss the lawsuit in the circuit court and the Court of Appeals. And three, parties would agree to mutual confidentiality, settlement terms and conditions. Now, generally, that's fine. Lawyers do it all day long. These are settlement terms. These are terms that are agreed. That's not a problem yet. There's nothing here. There's no sticky wicket yet. But wait, it gets good because they can't help themselves when they're scumbags. What do they say next? You may already be aware of the attached order entered earlier this month by a Florida court. That's the order we just read, right? The court found that Bruce Matskin engaged in the unauthorized practice of law, which is a felony. The court admonished Mr. Matskin and enjoined him from further such violations of the law. The court also noted that the finding of criminal conduct is referable to the Florida authorities for possible prosecution of Mr. Matskin. As such, and that's not true. It's not. It's only referable to the Florida bar to bring it to the Supreme Court. There's no other authorities. It's not going to the Attorney General, not going to the local, state attorney. As such, Mr. Matskin's issues arising from this development may just be beginning. He may face inquiries not only from the Florida authorities, but also the authorities in Connecticut and Massachusetts. Well, who do they mean by that? They mean the bar. This was all a play. This was all a play for them to try to screw with Bruce Matskin's livelihood. They concocted an order in a court and made it so they have to, he has to defend himself where he practices law. They're basically taking a big brown shit where Bruce Matskin eats. That's what they're doing at the end of the day. The jurisdiction in which he is currently licensed to practice law. Aside from illustrating that Mr. Matskin is likely to be occupied with matters more pressing than his claims against our clients in this lawsuit, the implications of this order also bear directly to Mr. Matskin's claims in this case. Development demonstrates the accuracy of his performance statements, and it stands in stark contrast to the representation made in your supplemental statement filed on blah, 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 blah. Anyway, I'm going to tell you what's going on here. Okay, and this is all in the article. You can read the rest. But what happened here is this guy right here, through his lawyer, right? We're going to put him on here, engaged in what's called horse trading criminal threats for a civil resolution. Now, you cannot, as a lawyer, be engaged in threatening crimes or the reporting of crimes or the existence of crimes in exchange for achieving a civil resolution in a case. That's like it smacks of extortion. That's what they call it. Smacks of extortion. So hold on. It's good. I'll show everybody what I've been drinking, actually. This is actually good stuff. This is what's called imba. Oh, they can't have that show because it's green. I have to show you another day. It's called cognitive soda. And it's got no calories. I think it's got like 30 or 40 calories a can. And it's like the cognitive soda. It gets you going, and it tastes good. And it's better than like the sugar-free Red Bull or that other energy drinks that are really, really terrible, terrible stuff. But it's called cognitive soda. They actually make it down here where I live in Southwest Florida. And IMBA, IMBA, Big Chill Energy. This one's the sour lemon lime. It tastes just like 7-Up or Sprite. That's the one I've been drinking. So I've had a little cough the past couple of days, so I'm getting rid of that finally on the tail end. So all right, let's get back to this guy. This scumbag lawyer, Larry Foreman, scumbag lawyer. So what happens? He proposes, stuff, but then he does something. That's the squeeze. He tries to basically squeeze using a criminal case. And I'm going to hit it over here, and we're going to show what this is. This is what's called the American Bar Association. Who are they? The Standing Committee on Ethics and Professional Responsibility. They are the people that regulate lawyers. They tell everybody what happens for lawyers. And this is a very specific one. You can click on my article to see it. The use of threats of prosecution in connection with a civil matter. Go read that email, and you decide for yourself whether they were trying to hang a criminal prosecution or threats about criminal issues over Bruce Matskin's head to try to force a settlement. Right? So they have a situation where you cannot go in, okay, and you cannot, in that situation, condition a civil case, okay, in order to go and basically advance or get a civil resolution without getting by advancing a criminal case. And so let me the clamped over here. Let me go back to this thing here to the original, and we are back over. Where are we? Here we are. Okay. Oh, I messed this up. Okay, share screen, and we're going to go with Content farm. That's what we were sharing. Okay, sorry. So that's what he basically did. He was doing a felony in order to, do something, try to get a civil settlement. So we sent Larry Foreman a note, and I want to read this. This is what the email to Larry Foreman was. Dear Larry Foreman, we are independent reporters working on coverage examining the Levy County proceedings that led to the December 2025 order by Circuit Judge Robert K. Grobe accusing out-of-state attorney Bruce Matskin of unauthorized practice of law and its apparent use in your Kentucky litigation. The timeline is raising serious questions. We want your side of the record before publication. Here's what the documents show. A Florida court order labeling Matskin's conduct as unauthorized practice and referring felony exposure, that same order being circulated immediately after issuance. A December 31st settlement communication from your side citing the order as leverage while demanding the dismissal of fees in the Kentucky case. The sequence matters. The order comes down, your motion to dismiss in Kentucky had just been denied, then the order becomes part of a pressure package. We need to ask you directly, did you or your counsel coordinate in any way with Randy Shockett or Jeremy Hales regarding the unauthorized practice of law motion or hearing? Were you aware in advance that such an order was being pursued? Do you believe it is appropriate to invoke potential criminal exposure to gain leverage in a civil settlement? Was the Florida order intended to influence the trajectory of the Kentucky case? This report is grounded in court filings, emails, and documented timelines. If there's context that changes the interpretation, we want to hear it. Please respond as soon as possible. We plan to go to press shortly. Receive your response after publication. We'll incorporate it into a follow-up. So we gave this guy a chance to talk to us, and he didn't want to talk to us. I don't know why he didn't want to talk to us, but he didn't want to talk to us. I don't think that's very nice. I see bearded on here, bearded fisherman. And do you think that was very nice of them, bearded? That Foreman didn't want to talk to me. I think that he should have talked. He should have talked. He should have actually given his side of the story. If he's got nothing to hide, why does he have the side of the story? So the Florida content farm, the truth in Levy County. The truth in Levy County is this. It's very, very simple. This case was brought in order to hurt Bruce Matskin professionally, and it was brought to build a courtroom story that turned into a content bonanza. Okay? So it's the litigation machine that is the issue here. And Jeremy Hales has developed a litigation machine through the courts. He has the courts, and he has the courts continue to do the creation of content. And so I'm still locked horns in, and we'll switch gears over to me talking about the Fed 2 case in a second. But the story we got here is that this is what this guy always does. All right, this is what Jeremy Hales does. Jeremy Hales, or the Germ, right? And and then bearded answer is like, why not, man? You're a cool dude. You're nice to talk to once in a while. Off the record. That's it, man. But yeah, he could have talked to me off the record. I would have talked to him, and he said, well, some of these facts are wrong. You got it wrong. It's not right. That's not true. I would have fixed it, but he didn't want to talk to me. And it's very, very sad. But so Jeremy Hales, and this is right. Sylvie, she said it right. Jeremy Hales goes after anyone who goes against him. Okay. And it's true. He takes us to another level to create content, and he doesn't allow freedom of speech. He has a lot of people who have their say. He tries to destroy anybody who goes against him. That's, for the 10 defendants that were dismissed in the Fed 2 case, that was just for speech. And they had to wait for, over a year to see that thing resolve itself, which is a load of happy horse shit. But it is what it is. So, and John Cook makes a good point. He says that judge was either the judge on Shockett's divorce or he was Shockett's lawyer. This Grobe guy has a conflict of interest. That's right, John. A good thing to bring that up. We didn't talk about it in this article. It might be something for another article. There's something called a conflict of interest when you're a judge. You cannot represent, if you represent somebody as a lawyer and you become a judge, you cannot sit on a case that they're in front of you because of the appearance of impropriety, right? If he was a judge on Shockett's divorce, then there could be an issue there. But if he was his lawyer prior, definitely he can't sit on that case. So that's an issue that we have to look at, and that's something that has to be explored. Now, let me go and I didn't do the whole big thing. Let me put that on the stage real quick because I wanted to show everybody this case and this is part of what was here. That was the earlier email that I did was to this woman who is the Miss Thomas, Candace Thomas. And this I'm just going to click through real quick. This is shock at going back and forth with this woman making emails October and this and that. And the point, what they're trying to get Bruce Matzkin for is sending emails to this court clerk, trying to clarify things and asking questions. Well, that's not what he wasn't doing anything that was the practice of law. He was just asking questions about different things, related to the case. And you could do that. Unless the court tells you, stop emailing me. We've had that in the Fed 2 case. The judge didn't stop the email. He said, order, no more emails. Screw you. We don't care about you, you little peons. No emails. So, but this is what the issue was. This is the major issue in the case is that this Judge Grobe tried to say that by Bruce sending a few emails to the judge, he got unauthorized practice of law. Now, that's kind of what Hinkle did in the Fed 2 case. I'll get into that in a second. But he didn't want to have emails. This guy didn't want to deal with emails, and so he's punishing a guy that he has no jurisdiction over that never appeared in front of him because they sent emails to the court attorney. It makes no sense to me. But what we got going on now is, let me see what we got. I have to put on what happened in the case, and then we'll put on some other stuff. Okay, let's see. Is this the one I want? All right, here we go. This is it. This is Fed 2. So we know Fed 2, right? And Fed 2 has order granting leave to file third amendment complaint against 2 defendants and directing entry of judgment against the others. So Germ filed a motion to file the third amendment, who's allowed to file the third amendment complaint. And under the federal rules of civil procedure, you have 14 days to answer. And I got the motion through the mail a few days after this got filed, probably 5 days after. And I had sent something in prior to that, which was a notice to the court, because the court had already said that I was not allowed to do emails. So I did something what's called a notice of pleading or notice of filing. And I put the email that I had with Randy Shaka on file with the court. And I was preparing my motion to file this past week because that's when it was due. And lo and behold, the judge came out with this order last Friday, Judge Hinkle. And so I'll read some of it. The plaintiff, Jeremy Hales, filed this action against 10 defendants: Lynette Michelle Lacey, Alexis Preston, John Cook, Bruce B. Matzkin, Lisa Weeks, a.k.a. Lisa Lee, Marla Hughes, Patty D'Agostino Plummer, David C. Helm, Robert J. Casey, David Michael Teshoff, and John Doe, a.k.a. Ray Bonecrusher. First amended complaint was added. Second, a plaintiff, Elephant Shoe, dropped Mr. Plummer as defendant, added a new defendant, Richard Luthman. Okay. Second amended complaint had the same plaintiffs and defendant would changes the designation of 2 defendants. Defendant previously referred to as Weeks, Lisa Lee, previously referred to as Doe, was Ray Bonecrusher. The notices of motions of 8 defendants, all but Preston and Luthman, were granted on March 11th. Luthman had been defaulted but moved to vacate the default and has now moved to dismiss and had not moved to dismiss at the time. Ms. Preston was in bankruptcy, so the claims against her had been stayed. The March 11th order granted leave to file a third amended complaint by April 2nd. Plaintiffs did not file a third amended complaint. April 16, one plaintiff, Hales, moved for leave to file a third amended complaint, naming only 2 defendants, Preston and Luthman. Luthman responded, ECF number 185, inappropriately attaching an email to opposing counsel rather than simply filing a response with the court. Well, this is what this judge thinks. I think this judge he's a senior status judge, and he was put in there by Bill Clinton, who happens to be Michael Volpe's favorite president. He's not my favorite president. I'll tell you why. He's just no good. But I think I found him because I think this guy is a holdover from the Miami Dolphins. I think I found his football card. I think that's the guy that we're talking about right there. I'm not sure. It could be him. It could not be him. I don't know if that's him. It could be his brother. It could be a relative. Or it could be, but that's what they said. They said he wasn't that good. They called him, Ray Stinkle. But I don't know. That might be the movie, Ace Ventura: Pet Detective. But the fact of the matter is, this guy made this ruling, and the ruling stinks. And I'll show you why. We'll show you why this ruling stinks right here. We'll go back to this. Where are we? Let's see. What is this? Orsha Papa. Oh, that's not the one we just talked about. There's the one we want. Stinkle. Where is he? Here we go. So, an inappropriate response with the court. Okay. And so, the order grants leave to file a third amendment complaint, but because of the bankruptcy proceeding simultaneously occurring, the proceeding against Ms. Preston remains stayed. Whether the third amended complaint could probably be filed against her may be unclear, but litigation can go forward against the other defendant, leaving the second amended complaint against her, while proceeding on a third amended complaint against the other defendant would undermine rather than serve the purposes of the bankruptcy stay. As set out in the March 11th order, the second amended complaint fails to state a claim. The deadline for further amended complaints, blah, 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 is also to keep the litigation. I explicitly determined there's no reason for delay and direct the court to enter judgment provided as below. Motion for leave to file the third amended complaint is granted. The third amended complaint is deemed filed. The clerk must enter judgments dismissing all the other parties, right? Mr. Helm's motions are going to be denied as moot. The claims against Preston and Lutheran remain pending, but all proceedings against Preston are stayed. So I'm the only one that it's going against it, right? And the case is remanded to the magistrate judge for further proceedings. So that's what Ray Stinkle did over here. That's his order, okay? And if anybody didn't see it before, that's Ray Stinkle, okay? And so, and he was appointed, obviously, by, President Epstein Island. And so what we need to go and look at is, what did this guy do? Is this guy right about this? And I'm going to tell you, no, he's not right. He's 100% wrong. Here's the third amended complaint, okay? And we talked about this third amended complaint on, we talked about it on with Michael Volpe and myself. And we talked about a very famous case called Hustler Magazine versus Falwell. And that says that when you're a public figure, satire, no matter how crass and no matter how emotionally distressing, is not actionable because it would destroy the First Amendment. So we have a substantive reason why this thing should not be amended, but yet the claim that they bring against Luthman here is a violation of the, I guess, the Revenge Porn Act. And I'll go to it right here. He said, Luthman published sexually explicit image of plaintiff. I don't know what image he's talking about. I don't think I've ever published anything sexually explicit. 2025, Luthman posted a video online depicting plaintiffs engaging in oral sex with a journalist. Did not show me a picture where I have anybody performing oral sex with Jeremy Hales. I don't know if Jeremy Hales was the one doing the oral sex. He doesn't say that here. Maybe who was the journalist? Was it Don Lemon? Was it Jeremy Hales and Don Lemon? Was Jeremy Hales having oral sex with journalist Don Lemon? That's breaking news today. Jeremy Hales had sex with Don Lemon, according to his own papers, maybe. We don't know. The images conveyed plaintiff's personal identification information through plaintiff's photograph. Guess what? Your photograph is not your personal identification information. Your personal identification information is your social security number, your bank accounts, things that people don't know just from looking at you. Guess what? Your face is something people can tell when just looking at you. When you walk into a public building, you show your face. That's it. There's no personal identifiable information. There's no expectation of privacy, you moron. Okay. Plaintiff was specifically identified by name in the URL and content where images are published. Yes. Why? Because, Jeremy, you have millions of viewers across all platforms. You are a mega influencer. You are a public figure, right? You are a public figure. And, oh, John just raised the point. We're going to stop for a second. This judge is allowing you to go forward, Michelle, stay, but yet he won't allow me to go forward in Fed 1. This is true. This is what's called not equal protection or equal rulings of the laws. How can I go forward on one and you not go forward on the other? This is incongruous rulings. This is some crazy stuff. That's what we got going on here. We have a court. You know, what are they doing? They're showing that the rule of law is arbitrary. I can go ahead, but John Cook can't go ahead. I'm forced to go ahead. John Cook has stayed. Does John want to go ahead? John doesn't want to go ahead. Who knows? But he doesn't have the opportunity to do what I do. That's how crazy this is. So we'll go back to here. Plaintiffs' physical attributes are readily identifiable in the posted images. Now, I'm trying to understand what he's saying by physical attributes. What do you mean? His eyebrows, his nose, his mouth? It's not like I'm saying that there were physical attributes. He's trying to say his penis, because he's not showing us that it was lewd imagery or his private parts. He doesn't say that here. This pleading does not say that Jeremy Hales was seen with private parts in his mouth performing oral sex, or that he was performing oral sex, or whatever. It doesn't lay it out what actually happened. The image video was published to an internet website. No, that's not true. It was published to many internet websites. In fact, it's all over the internet. It's in over dozens of places at this point, in foreign places, in domestic places, in foreign countries, in places that I may have control. I don't have control over others. Though it's been reposted by others. It's all over the place. The video was published at the following internet address, lupin.substack.com. Yes, it's there. Go watch it. If you want to watch it, you can go watch it. Megan Fox's, it's called Megan Fox's bedtime story. That's what it's called. Plaintiff did not consent to the publication of the image. Well, look at this. I heard from our friend in Colombia, posted it out there too. Yeah, they posted it in Colombia. The Colombians love Jeremy Hales and oral sex. So that's what happened there. So the video was published, and plaintiff did not consent to the publication of the image. You don't need to consent to a publication of an image if you're a private figure. Do they go and get Donald Trump's written permission every time they put a picture of him in the New York Times? No, you are a public figure. That's it. It's over. Plaintiff never consented to Lupin publishing any images of plaintiff. Okay, it doesn't matter. Okay, plaintiff did not authorize, approve, or give permission for the publication of the images. Okay, it doesn't matter. There was no legitimate purpose of publishing. Oh, yes, there was, sir. It was a satirical purpose. There was a legitimate journalistic, satirical, educational, documentary, scientific, artistic reason for why it was published. It was actually a critique. If you watch the video in its entirety, it's not Jeremy Hales' voice. It's actually public figure Andrew Tate's voice. And Andrew Tate, the public figure, is talking about how he likes to pimp hoes. And there are people that are hoes, and he just wants to pimp hoes. And I was doing it in a critique for Megan Fox's bedtime story, meaning that she dreams that a big man would come along and exploit her the same way that Andrew Tate exploits the women that he talks about, and evidently the same way that Jeremy Hales exploits the members of his Hales ecosystem. It's an exploitation situation, in my opinion. And I have every right to my opinion and my satire to raise issues about the cult-like behavior, about the exploitation that I believe that might be going on. The publication, Lupin had no relationship with plaintiff that would justify publication. Yes, I do. I'm a human being. And I have a relationship with something called the First Amendment. Because I have the First Amendment, I have a right to speak my mind in America. I do have a legal relationship. It's called the First Amendment. I'm also, on top of that, a member of the press. On top of that, I have the extra protections that I'm raising journalistic and newsworthy issues. Next, the publication was not newsworthy. Of course it was. You're a public figure. When you're a public figure, there's a height level of what's newsworthy and what's not. Defendant Lupin intended to cause substantial emotional distress to plaintiff. It doesn't matter whether I did or I didn't. Why? Hustler Magazine versus Falwell. The United Supreme Court says it doesn't matter. Now, for those of you who know or don't know the Hustler case, Larry Flint said that in a satirical way in an ad in Hustler Magazine that Jerry Falwell's first time was with his mother in an outhouse. And it was clearly satire. No one could have believed that it was true. Okay? Never could have believed. And oh, wait, that's a good point. When did Preston and Cook consent to Hales using their images? That's true. Jeremy Hales uses Preston and Cook's images. What's good for the goose is good for the gander, right, Jerm? What is that? 89. Plaintiff did not authorize or give permission for the publication of the image. Neither did Cook or Preston. No legitimate purpose. Neither did Cook or Preston. Posted to harass and defame. That's Cook and Preston. That's what you do, Jerm. This is projection. We have found projection. Thank you, Candy. We found ourselves projection in the third amended complaint. So, Lupin intended to cause substantial emotional distress to plaintiff. Does not matter. It does not matter. Supreme Court says so. Defendant Lupin with intent to cause emotional distress is evidenced by the context of the publication. My intent doesn't matter. If it's satire, it's protected. That's what the Supreme Court said. Prior to publishing the image, defendant had sent emails making false accusations plaintiff was an anti-Semite and comparing plaintiff to advocates of eugenics and mass murder. Well, let's break that down. Did Lupin send emails making accusations that plaintiff was an anti-Semite and supported eugenics? Yes. Did Lupin send emails to that effect? Yes, I sent emails questioning it to people to have people take a look. Yes. Were those accusations false? No. I have good faith from a rabbi, a holy man. I have from other people who are Jewish. I have from my own research showing two things. One, Jeremy Hale's talking about this word deuce, foreskin, that the foreskin, that's anti-Semitic because there have been Jewish people that have died to have the covenant with Abraham, to have their children, the male children's foreskins removed as part of the covenant with Abraham. There are Jews that have died. So to make light of that is 100% wrong. It's just 100% wrong and anti-Semitic in people's opinions. And are you anti-Semitic or not? That's my opinion. That's how I feel. Okay, so it's an opinion. It's not even worthy of defamation or truth value. Number one, but I think it's true. I believe it's true. I believe that Jeremy Hale's anti-Semitic. Number two, the eugenics part is how I gotten the term paint chips. This is going to bring in the whole paint chips thing. Every time he says the word paint chips on air, that proves that the eugenics and mass murder issue is not a lie or not false, because I was talking about Megan's claim that about Darwin and about how little black children who were in the housing projects should have lead paint, and she was kind of sympathetic to the fact that little black children should have lead paint and eat the paint off the walls in the housing projects. And as second I brought that up and attacked them for it, they started calling me paint chips. The reason why I got called paint chips because I was defending poor black and brown children in New York City housing projects that were strucken with lead paint and caused defects, brain damage. These people don't care. That's what a eugenicist is. That's what Adolf Hitler cared about. He cared about the Aryan race, right? He wanted to kill everybody. Let them all die that are no good. Let the Jews die. Let all the people with brain damage, let all the little kids that are deformed, let them all die. That's what I believed Megan Fox and Jeremy Hale to be talking about. And then they turn around and they called me paint chips. It's a disgrace. The publication was designed to humiliate and distress plaintiff. It doesn't matter what it was designed to be. It doesn't matter if it humiliated or distressed them. It only matters whether or not it was satire. To that extent, it was designed to be satire. Defendant Luther knew the publication would cause distress. Oh, yes, because I have a crystal fucking ball. These guys are like the biggest idiots in the world. That's a non-provable statement. I knew the publication would cause distress. I can't tell you when I publish an article how many people are going to read it. I couldn't tell you how it's going to be received. I can't tell you what people are going to say, but I knew that a satire video that I made was going to cause somebody distress. That's a load of happy horseshit. There's a Facebook page called What the Hales. It appears to be an official Facebook site of What the Hales, where the Hales comment group of Hales to surprise find supporters. There's nothing more than a hate group designed to damage the reputation of Hales. Guess what, Jeremy? You're doing a great job of damaging your own reputation all by yourself. You're terrible. You really are. It's a hate group. Get the hell out of here, a hate group. Nothing designed. I'm not damaging your reputation. How can I damage your reputation? You're a public figure. I'm talking about public interest things and that are true. I'm talking about satire. I can't. This is all First Amendment protected. It's out of control. And what does that have to do? Designed to damage your reputation. What does that have to do with respect to the statute that you're bringing on? Luthman personally posted to this hate group. Okay, I posted plenty of Facebook groups. Some examples of the posting of this group are at this. I don't even think that's up anymore. But I'll post it again. I don't care. Defendant's conduct or harm occurred within Florida. I live in Florida, but there's no harm, and my conduct is not actionable. Plaintiff maintains property in Levy County. Okay, yeah, you're a carpetbagger from Ohio, and you have a house in Levy County that I'm going to own very soon and make it into the Otter Creek. What are we calling it, Bearded? We're going to call the Otter Creek Funhouse or something like that. That's what we're going to call it. Otter Creek Funhouse. I'm going to own the house in Otter Creek, and it's going to be given to charitable or other devices to make it into the Otter Creek Funhouse. Plaintiff conducts business operations in Florida. Okay. Plaintiff suffered harm to his reputation and emotional well-being in Florida. Okay. Wasn't caused by me. Plaintiff suffered damage as a result of Luthan's sexual cyber harassment. I think he's probably more popular because of the satire video I made, but it's not sexual cyber harassment. Did he have sex with Don Lemon? And that's what tell us about. He hasn't described the video. He hasn't told us what the video is. He hasn't said what happened. He hasn't said that he was naked. There was any lewd pictures. There was anything there. So there's nothing here that's like, put it this way. There's no part of that video that wouldn't pass a censor, right? There's no part of that video that would say, oh man, that's rated X. Nothing at all. That's the best part about it. It might be, stuff for late night television. It might, PG-13, or even R. It's not lewd. It doesn't cross into the sexual world, and that's the big issue. Plaintiff endured extreme embarrassment as a result of the publication. Well, you know what? You shouldn't have engaged in the conduct that you claim to have engaged in then, Germ. If you engage in the conduct, right, and it's not pornography, then you can't be angry about it. If you had oral sex with Don Lemon, for example, you cannot be upset that you blew Don Lemon if that was what happened. I don't know if it did, but if it happened and Jeremy Hales blew Don Lemon, we don't know if that's the case, right? We don't know. We just don't know what happened. And so at the end of the day, you have to have situations that explain in the sexual act that he talked about. We have to tell the situation there, and they have to talk about it. So I don't know. They haven't done that. Praise lost professional opportunities and prestige. He felt strain on his personal relationship. Oh, strain on your personal. Get the hell out of here. Plaintiff included prolonged expense and inconvenience. Plaintiff's total damages harassment amount to $375,000. Now this is something I want to see. Plaintiff's total damages from the sexual cyber harassment amount to $375,000. Germ, your damages don't amount to $3.75. You are out of control. There's no way you can prove it. There's no way you can allege it. You cannot show contracts that you lost. You cannot show business that you lost. You can't even show anything that happened to you as a result of this. You're probably bigger and more important. I'm going to send you a bill because I'm bringing you new audiences because, nobody really cares about you. Okay? But let's get back to the issue at hand. We went through this whole thing. This is the BS thing and shock it and this and that. All right, fine. So that's what came across. And so then there is a, where are we now? This just went across today. This is brand new news. Breaking news before, what's her name? The fat slug. What's her name? I forget her name. You know her name? What's her name? The fat slug. Oh, yes, Megan Fox, the fat slug. Okay. Yeah, so she, before her and Tug and Jay Jip and Shizzy No Nuts and a whole rest of them, before they can go on and try to read this stuff on air and pretend that they know what the hell's going on, I'm going to read it and tell you what's going on here. Okay? Defendant Richard A. Luthman Jr.'s notice of non-consent to magistrate judge jurisdiction. Defendant Richard A. Luthman Jr. appearing pro se and specially hereby provides formal notice that he does not consent to the exercise of jurisdiction by a United States magistrate judge for all proceedings in this action, including trial and entry of judgment pursuant to 28 U.S.C. 636C and Federal Rules of Civil Procedure 73. Defendant expressly withholds consent to any expansion of magistrate judge authority beyond that permitted by 28 U.S.C. 633B, while defendant recognized the magistrate judge's role in handling appropriate pretrial motions and issuing reports and recommendations. Defendant insists that any dispositive rulings, including motions affecting jurisdiction, dismissal, or final adjudication, be made by an Article III district judge. This notice is filed to make defendant's position unmistakably clear and to prevent any implication of consent by silence, inaction, or procedural default. Defendant is proceeding pro se under a limited and special appearance and is actively contesting threshold issues, including has not limited to service of process, personal jurisdiction, the legal sufficiency of the claims. Those issues go to the court's authority to proceed and must be reviewed by and received by an Article III judge. Nothing in this notice constitutes a waiver of any defense of the Federal Rules of Procedure 12, nor does it operate as a general appearance. And look, I sent it, and it went to the shock it, rocket, pocket, rocket, shock it. And it went to the clerk of court. And it's stamped on the top. See, it's in there. Document 190. It's in the court. All right. What else got to the court today? Let's see if we have it here. Where is it? Yes, here it is. Richard Luthman. Now, this is what I have to go back to this. We have to show the picture of my favorite person again. So, this guy jumped the gun. The Federal Rules of Civil Procedure turn around and say, you got 14 days to file. The local rules say you got 14 days to file when they have a situation, right? When they file a motion. So Shockett files a motion, right? He files the motion, and what happened? He didn't meet and confer with me. So this guy already said, this could be his brother. I don't know. I heard he was on the Miami Dolphins. Anyway, this guy said, look, don't send any more emails. It won't end well for you. You won't be happy. I'm going to put you in jail. He basically threatened me to go to jail. He threatened everybody else too, but nobody else is in the case. You're going to go to jail. The feds are, FBI's involved. G-Man's coming. Sound like anybody else we know? You're going to go to jail. You're going to jail. It's not going to end well for you. Rawr! Well, that's what happens here. He sends that and says, you're going to go to jail if you send me another email. So what does Rich Luthman do? I did what's called a notice of filing, and I will put it up again, okay? This is what I had filed, and it's actually part of this document, okay? It's a notice of filing, and I'll get into it, but it's one of the things at the end of this this document. This is a motion here, okay? And there's my declaration where I talk about everything. And in the declaration, this is the case from New York, and I'll talk about that in a second. And here is what I did. It's already filed as document 185, and it was filed again as 191.11. Notice of filing of April 5th, 2026, email regarding local rule 7.1b conferral and counsel's professional conduct. Defendant Richard Luthman Jr., aka Richard Luthman, appearing pro se and specially as appropriate, hereby files and serves the stated April 15, 2026 email correspondence sent by Luthman to plaintiff's counsel Randall Shockett concerning plaintiff's asserted conferral under the local rule 7.1b and related issues of professional misconduct. The attached correspondence is filed as Exhibit A and speaks for itself. The correspondence is relevant because it placed plaintiff's counsel and express on the April 14th email from Shockett Law Group did not satisfy the meaningful conference requirement of local rule 7.1b. So he didn't meaningfully confer with me. Local rule 7.1b requires before filing motions or raising an issue, an attorney for the moving party must attempt in good faith to resolve issues through a meaningful conference with an attorney for the adverse party. The rule further says one email or other writing at or around the time of filing the motion is not a meaningful conference, right? Local rule 7.1b also provides that when conferral is reduced in writing, it's not afforded in at least 24 hours under the federal rules. That's no good. The attached correspondence expressly objected to the counsel's email. It was not a conference, but really a notice of intent to file and requested an actual meaningful conference consistent with the rule. The conference is further relevant to my certificate of conferral, to any certificate of conferral. So he did a certificate of conferral, Shockett did, and the certificate of conferral was perjury. It looks like perjury to me. It looks like it was misstated. It looks like it contains false statements. So I put all this stuff on the record, right? I put this here. I sent it to the court. I can't email this to the judge, so I sent it there, and I put his whole email here. I said, your April 14th email does not satisfy meeting conference requirements of local rule. Here's the rule. Your message is no good, blah, 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 blah. I give all the case law. Well, I send this to put this on the record because I wanted to create a record of this, right? That's all I did here. I created a record, okay? And here's that email again. That's the email. And this is when I tried to, before I filed this motion, I actually conferred with Shockett. I sent this email on Friday, April 24th, and I didn't hear anything from him. And so, it's got filed today. It's the 29th. He had all the time in the world to confer. So I tried to confer with him, and he doesn't respond to me. So it's not meaningfully that he tries to confer. It's what's called an exercise in futility. As a matter of law, try and confer with this guy. He's not responsive. He doesn't notice. So I filed this motion saying, Judge, and we'll put the judge's picture up again because I love the judge. He's so great. Look at him. You have to respect somebody who played football. And I don't care who you are, what position you played. If you played football in the NFL, you're a swell guy. So that's all I got to say about that. There's the judge. So here's to you, Judge. Okay. So we got a situation where I file this motion, and what I'm talking about in this motion, I talk about a couple of things. The first thing I talk about is myself, purported and palpable defendant Richard A. Luthman Jr. What does that mean? Purported and palpable. This whole first sentence that I write is a packed sentence with legal meaning. We're just going to talk about the first couple of sentences here, and I'm going to read maybe the first section, and you'll have the whole idea what's happening. I made this very easy for everybody to be able to read. Purported and palpable defendant Richard A. Luthman, defendant or Luthman, a non-lawyer expressly unskilled in the science of law and presently lacking the functional capacity to be learned in the law. Okay, purported and palpable. Well, I don't know if I'm the defendant because I've never been served. Jeremy Hales has yet to serve me with papers. It's April 29th, 2026. Jeremy Hales has failed to serve me under Rule 4. He may try to file a motion against me to try to collect money for the costs of service. That motion will fail. If he does that, I'm going to actually file for sanctions and for SLAPP and for a bunch of other things against him too, if they even try that. But the fact is, he didn't serve me with papers correctly, ever. He served my father. I don't live with my father, served my father. He never had me. This complaint that we just put in there, the third amended complaint that hit the docket yesterday, April 28th, 2026, is the first time that Jeremy Hales has ever said I'm a resident of the state of Florida. These morons tried to serve me in New York. Did they come to my house to try to serve me? Sure. They said I wasn't home. Okay. I got shit to do sometimes. Yeah. I'm all over the place. You could have served me. Does the guy call me up and say, you want to accept service? You want to come to a deal? You want to do this? No. Did I give him a chance to accept service? Yeah. He could have dropped Ray Bone Crusher from the lawsuit and I would have taken service from him. He had plenty of chance to get me. Did he get me? No. Did he come to my house? He says he did. You know what he said? He said he saw storm shutters up. Oh, okay. Storm shutters were up. And he thought that the house was abandoned because hurricane shutters were up. Guess when he came to my house? Last August. When is hurricane season in Florida? August. August and September are the height of hurricane season. If you don't have hurricane shutters up in August and September and you live in Florida, you're a moron. You are a moron. You welcome yourself to the Darwin Club because when the shit comes through, you're not going to be there after it's gone. You put your stuff up. You put your plywood up. You put your shit up. The hurricane shutters, you keep them up. And you can keep them up the whole month because you don't have to take it down. That's what they do. You keep the hurricane. People in Florida can tell me. You keep them up. That's how people roll. Some people take it up, put it down. Some people have the ones that go. Some people just keep them up the whole time. You know, that's how it rolls in Florida during hurricane season. So, purported and palpable. All right, next. Non-lawyer expressly unskilled in the science of the law, presently lacking the functional capacity to be deemed learned in the law. That is a loaded sentence. I used to be a lawyer. And so they're going to say, well, no, you're skilled in the science of law. You're learned in the law. No! And I have a footnote there that shows it, right? Tenenbaum versus United States is a case, and In re Teigen is a case actually in North Dakota that talks about it. But Tenenbaum versus United States, the 11th Circuit case, if you're not a lawyer and you can't hold a law license, as a matter of law, you are not learned in the law. So I'm not learned in the law. Well, they say, well, you have some skill in the law. You know what you're doing with the law. No, I put another case down there. That's called United States versus Luthman. That is the case that Megan and Jay Jip and Tug and all these other people have been reading. They've been reading about Luthman did this, and Luthman did that, and Luthman did this, and Luthman did that. Well, fine. A part of that is a finding by the judge. His name is Judge Jack Weinstein. The guy's dead. Okay? He's one of the best judges that ever was. Because anybody who's a lawyer will tell you he wrote the book on evidence. You have evidence? There's a book called Weinstein on Evidence. They cite it all the time. When the judges need to look up something on evidence, they look up Weinstein on Evidence. This guy made an evidentiary ruling in the case, a factual ruling, that Richard Luthman, right? The things that Richard Luthman did were absurd, bizarre, and ruthless. And that even though he had a legal training, and he was actually trained very well as a lawyer, this guy's too batshit crazy to be able to render competent legal advice to anybody, to third parties, or even himself. So this judge basically said, I can't be someone that can be deemed to have the functional capacity to be learned in the law. And even if I have experience prior with the legal system, I'm too batshit crazy to have it be sound legal advice. Really? What lawyer would go around and show pictures like this on the screen about a judge that they're in front of and think it's not a bad thing? I think this is a great thing. This is the First Amendment in action. I love the First Amendment. This is like Larry Flint type stuff. This is like, diaper, American flag in a diaper in the courtroom. When they're crapping on the First Amendment, you let them know. And that's what I'm doing here. So this is what that judge said. That's what this judge said in the very, very beginning. So I appear pro se and specially, I'm by myself, pro se, specially, I'm not making a general appearance just to contest jurisdiction, not in submission to the court's authority, but in direct challenge to it. I'm challenging the court's authority because I haven't been served. Nobody served me with papers. Not a general appearance. It is a compelled intervention to halt a procedurally defective proceeding that has lurched forward without valid service, without jurisdiction, and without adherence to the most basic requirements of due process. Defendant has never been properly brought within the court's power under Rule 4, and yet finds himself named, previously defaulted, admonished that things will not end well, and pursued through a claim of errors, omissions, and legal theories that will not survive first-year civil procedure scrutiny. Defendant appears now for one purpose only: to expose the jurisdictional void, to prevent further reliance on defective process, and to insist that this litigation proceed, if at all, within the bounds of the federal rules and the Constitution. He does so while expressly preserving every defense available under the Federal Rule Civil Procedure 12, including lack of personal jurisdiction, insufficient service of process, lack of subject matter jurisdiction, and failure to state a claim. That's a lot. I'm preserving all my rights. I have lots of rights I preserve. Accordingly, this is what I asked for. Without waiving any rights, defendant hereby moves for the following: clarification and or consideration of the court's April 23rd order. That's the 186. That's what Hinkle just had. Pursuant to Federal Rule Civil Procedure 54B, to address whether the order was entered prior to the expiration of defendant's response period under Local Rule 7.1E. That's the amount of time I had to respond to the motion, and the Federal Rules of Civil Procedure as well. He just made his ruling, and he said, okay, screw you. Second, leave nunc pro tunc, now for then, to file a full merits response in Rule 12 motion when defendant's prior filing was deemed to confer all deficiencies and was not intended as was directed towards a confer all deficiencies, not intended as a substantive opposition. I put that thing in there to preserve it for the record. I didn't do it as an opposition to a motion. It was there for the record. That's all that was placed there for. Third, an order permitting prompt Rule 12 briefing on threshold defenses, including insufficient service of process, lack of personal jurisdiction, and failure to state a claim. He didn't serve me. He put this in April. He amended it again in July. He has 90 days. He didn't tell me why I didn't get served. He hasn't served me with papers. I haven't served properly. He improperly tried to serve my father. He improperly tried to serve the Secretary of State. He's a moron. His lawyer's a moron. There's a pack of morons. They bear the burden of showing the process was done correctly. And that's what they're going to have to do. I'm holding them to their facts. Alternatively, reconsideration leave to amend as to defendant on the grounds that service and jurisdiction remain unresolved. The proposed third amending complaint is futile as a matter of law. Well, that's the Larry Flint stuff. That's the First Amendment. He did not state a cause of action. A claim of relief cannot be granted. Let's go into court and let's play the video for the judge and let him laugh and say, how the hell is this in front of me? Why are we wasting time? That's really what this has to be done. That's all we have to go to. We have to just go to this guy and play the video. I don't know if it's him or it's his cousin or whoever, but he got to play the video for this guy and let him laugh and say, is this thing for real? Is this thing for real? Is this what you're bringing me to court for? So, and an order directing all future or all reasons necessary to defendant a meaningful opportunity to be heard, consistent with the Federal Rules of Civil Procedure and fundamental due process. They can't make light of the deficiencies and disabilities that Judge Weinstein recognized. They can't hold me to a higher standard than I should be held. I should be held to a standard where they give me some latitude. I think I should have that, right? Weinstein did. I don't know. Does this guy think he's better than Weinstein? I don't know. An order directing that all future service on defendant include proper service and a courtesy electronic copy to Richard Lupin at protonmail.com to mitigate the structural disadvantages. And that's true. There's something called the structural disadvantage, because what'll happen is Chocolate will file something or email something or throw something, and they can confer by email. They can send things by email. I don't get stuff till days later by the mail. It's 3, 4, 5 days later. If it's due 7 days or 14 days, that's a disadvantage. Send me a courtesy email. All I want is a courtesy, right? And that's all I want. Let's see if they'll do that. And other relief as they deem proper. And so those are the points that are here. And we've already done about, I don't know, we're on for a while now. So I don't want to belabor this point. We're on for an hour and 20 minutes. I don't like to go for more than about an hour 15, hour 20. We'll see how if people like this. You know, I think Miss Lori says it best right here. I'm still amazed this is in the courts. Old days of good bitch slapping would have stopped all this. Blame participation awards, feeling, and safe place for this insanity. And that's true. That is very, very true. You know, this is like, what are we doing here? And the fact is, and I tell the judge in this, and maybe I'll come back on a live tomorrow or the next day and read the rest of the preliminary statement or some of the other stuff in here. We'll get into it. I think that would be pretty cool, actually. But I'm gonna get off now because what I want to do is I like to keep these things short. That's really what I like to do. I don't like to go for 3, 4 hours. I like to go for hour 15, hour 20 at the most. And we're right here on the preliminary statement. Maybe we come back and read that. We talked about the Bruce stuff today and how that whole unauthorized practice of law thing is a sham. And now this thing's a sham too. And I'm going to show everybody that it's a sham. All right. So I would like to thank everybody for coming on today and watching this. But these things are now on the docket. They're filed on the docket, and we'll see where this goes with this case. The case Fed 2, it's not over, you know, by any stretch. I'm still on this case, and they're still doing what they got to do with me. I don't know. I haven't been served correctly. You know, they might dismiss it on that grounds. I really don't know. And the question is, am I going to get the Article 3 judges that I'm entitled to? I don't think I have a problem with belief, though. But then again, I want the Article 3 judge. I'm entitled to that. And this guy doesn't want to have anything to do with this case. He's like, no, this case is only Lupin, and I'm giving it to the magistrate judge. No, you have not resolved service. You have not reserved Rule 12. You have not resolved this. You have not resolved that. So that's what I'm going to do. I'm going to end up telling these guys what they need to do. And, you know, it is what it is. So that's how it's going to roll. All right. So I'd like to thank everybody for coming on. I'm going to sign off, and maybe I'll come on tomorrow or the next day and explain the rest. Thank you, guys.